In last Friday's lesson, we talked about Article 21 of the Civil Code in relation to Articles 19 and 20. We talked about the distinctions of the cause of action under Article 20 and 21. Under Article 20 of the Civil Code, the basis of the action is always an unlawful act or an act that is contrary to some specific provision of the law, and that such act must be done willfully or negligently. On the other hand, an action under Article 21 of the Civil Code is one that is also called contra bonus mores. It can never be committed by mere negligence, only through a willful or voluntary act. In last week's discussion, we also talked about the specific instances when a breach of promise to marry becomes an actionable wrong. In our discussion, we noted that there is an action under Article 21 when the breach of promise to marry is coupled with seduction, when the promise becomes the proximate cause for sexual intercourse, and there is proof that there was never any intention to keep that promise. And finally, when extensive preparations for the wedding have been made. In case you missed this discussion, there will be a link to that in the description down below. Today, we're taking a look at Article 22 of the Civil Code. This provision defines for us the principle of unjust enrichment and the cause of action that's also known as action in rem verso. By the end of today's lesson, you should be able to 1. Identify the principle of unjust enrichment, 2. Identify the different requisites for an action in rem verso to prosper, 3. Distinguish action in rem verso from solutio indebiti. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 22 of the Civil Code provides that every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of another without just or legal ground, shall return the same to him. Ang Article 22 ng Civil Code, kapatid, ay tinatawag ring Principle of Unjust Enrichment. Alam ko medyo technical pakinggan pero hayaan mong gabayan kita para maunawaan mo kung ano ang sinasabi ng batas sa provision na ito. Sa mga katagang unjust enrichment, hatiin natin, kapatid. Unjust here means unfair, pwedeng illegal or pwedeng legal, pero malinaw nang na hindi patas. Enrichment, karagdagan o naidagdag. Katulad ng nabanggit ko sa mga una nating lessons, kapatid, ang batas natin, at least sa Pilipinas, ay allergic sa mga taong mapang-isa, mapanlamang at mga taong abusado sa kabaitan ng iba. Makikita natin ito hindi lamang sa mga decisions ng Supreme Court, kundi maging sa mga codal provisions gaya ng Article 19 at tulad ng Article 22. Sa ilalim ng principle ng unjust enrichment, merong isang taong nakapanlamang ng kapwa. Merong napuntang pera sa kanya o nakinabang siya sa isang bagay na hindi naman niya pinagpaguran, hindi niya pinaghirapan at higit sa lahat, hindi naman dapat mapunta sa kanya. Just like some of the provisions of the chapter on human relations, Article 22 is an admonishment or a firm warning that is addressed to everyone, to all persons, be they natural persons like you and me or artificial persons like corporations, partnerships, and city governments. Article 22 tells us that anyone who acquires or comes into possession of something. This means that the law on unjust enrichment does not distinguish on the nature of the thing or value. Hindi material kung pera yan, service yan, bagay yan o ulam yan. Hindi rin material kung ang bagay na iyon ay binigay or napunta lang sa'yo, kapatid. Nevertheless, in the next line of the codal provision, the law adds a qualification: at the expense of another, meaning may isang taong nawalan, nalugi at nabawasan ng yaman. At ang napunta sa iyo ay walang legal basis, without just or legal ground. Then the law imposes upon you, kapatid, the duty to return the thing. Sometime in the late 1990s, my mother had this idea of helping us save money for ourselves. Following a bumper year ng pamamasko, my mother noted that my brother and I received a lot of cash gifts, enough for us to open bank accounts. I was very excited at that time. Hindi ko pa nga alam kung ano ang pirma. Basta sabi lang ng nanay ko, isulat ko daw ang pangalan ko ng cursive o dugtong-dugtong. We walked out of the bank with a small book with numbers. The lady at the counter told me and my brother that the number represented our money, our deposits. Hindi naman namin masyadong naiintindihan yon, kapatid, dahil nga numbers lang yon at hindi sila pera, hindi sila peso bills. The lady at the counter also showed us how to use the small plastic cards that came with our books. She told us that we were to select a secret number for each of us and to never tell anyone of the secret number. She inserted our plastic cards into a part of the wall, which as an adult I now know as an ATM, and the screen displayed the amount of money we each had. From time to time, my brother and I would make money doing chores, working for our neighbors, and selling some of our chickens and pet rabbits. We would ask our mother to make deposits. One Saturday morning, my brother and I were out biking when we thought of stopping by the ATM to check our money. Lo and behold, my brother found that he had 26,000 pesos on top of his savings. We were shocked. As little children, we thought that money was ours to keep. Sino ba naman kasing 10 years old ang hindi magtatatalon sa tuwa, kapatid? Remember that this was the late 90s. Malaking halaga ang 26,000 noon. Ang BMX nga noon at mountain bike, maganda na ang 1,500 or 2,000 pesos. He withdrew 5,000 pesos. I then proceeded to check my balance and I found I had no extra money. Hindi ako nabiyayaan, kapatid. On the way home, my brother told me to keep this a secret. Later that afternoon, he went off to buy himself a pair of shoes. For whatever reason, my mother found out about my brother's brand new Jordan 11s. She was shocked. We told her the whole story. The next day, she went to the store to return the Jordan 11s. The owner of the store knew my mother and accepted the return. On Monday morning, my mother went to the bank with my brother to return the 5,000 pesos and to report that there was some discrepancy with his account. At sabi nga ng kuya ko, Jordan na, naging bato pa. In this case, there was unjust enrichment on the part of my brother. He acquired or came into possession of the amount of 26,000 pesos. He received it without just or legal ground. While my mother may not have heard of Article 22 at that time, she came forward with my brother to return the money to the bank. As it turns out, there was an erroneous deposit made in favor of my brother. May nagkamali ng punch ng account number and it happened to land on my brother's savings. About 2 or 3 months later, basta bago mag-start ang bagong school year, nabilhan din ng Jordan 11 ng kuya ko. He received the shoes for his birthday. Ang classic na halimbawa sa mga libro ng unjust enrichment ay isang sitwasyon kung saan sobra ang nagiging sukli. With all due respect to the authors you will be reading in the weeks and months to come, I do not agree. And at the end of this lesson, I will show you why. For now, let us stick to the requisites of unjust enrichment as discussed by the Supreme Court. In Halandoni versus Encomienda, the Supreme Court lays down the following requisites for unjust enrichment. There is unjust enrichment under Article 22 of the Civil Code when 1. A person is unjustly benefited. 2. Such benefit is derived at the expense of or with damages to another. When it comes to unjust enrichment, dalawa lang ang hinahanap natin, kapatid. Una, mayroong isang taong nagbabayad kahit wala siyang obligasyon na magbayad. Pangalawa, may isang taong makakatanggap kahit malinaw na wala naman siyang karapatan na makatanggap. Before we discuss action in reimburso and solutio indebiti, I'd like to spend a few minutes to discuss the cases. The first case is Halandoni Osmeña versus Encomienda. Don't worry, kapatid, if you do not get the citations for the cases because I will be leaving links to these cases in the description down below. Carmen Encomienda filed an action for collection of sum of money against Georgia Halandoni Osmeña in the amount of 3.24 million pesos and $6,600 sometime in 1997. Again kapatid, this was the late 90s. Malayo ang nararating ng pera noong araw. Please take note of this to better appreciate the case. Encomienda claims that she met Osmeña in 1995 when she was buying a condominium unit in Cebu City. They became close friends. In March 1997, the children of Georgia Halandoni Osmeña went missing and she asked for the help of Carmen Encomienda. To this, Carmen acceded and handed a sealed envelope containing 100,000 pesos to Osmeña's security guard. Marahil kapatid, ikaw ay nagtataka na kung bakit may security guard si Georgia Halandoni Osmeña. To give you more context, the defendant in this case, ang taong sinisingil, ay isa sa mga anak ng dating senador na si Sergio Osmeña Jr. Georgia was also married to one of the richest families of hacienderos in Iloilo. Bigatin si Georgia dahil nakatira siya sa isang bahay na may security guard. Georgia Halandoni Osmeña thereafter went to Manila to search for her children. She incurred a lot of expenses, including the publication of the pictures of her children as missing persons, plane tickets for her secretary and her psychic friends, various cell phone and cable bills, bills for pagers, the salary of Georgia's retinue, filing fees, prayers for her children, and even 17,500 for the ritual performed to drive away evil spirits. All in all, the total reached about 3.24 million pesos and $6,600. Carmen Encomienda was able to prove all of the expenses she had advanced in favor of Georgia and her search and rescue mission. A member of the Lupong Tagapamayapa testified that Georgia acknowledged that she borrowed money from Carmen and that she would pay it back. In her defense, the daughter of the former senator argued that there was never any talk of a loan and all of the expenses advanced by Carmen came out of the goodness of her heart. And that when she would ask Carmen, her friend would say she just wanted to help and there was no loan. Let our response be, wow, sana all. Sana all ay may tropang mamimigay lang ng 3.24 million. The Regional Trial Court of Cebu City ruled against Encomienda. It gave credence to the argument of Osmeña that indeed there was no loan at all. On appeal, the Court of Appeals reversed the Regional Trial Court and held that Georgia Halandoni Osmeña should be liable to pay the expenses advanced by Carmen Encomienda. The Supreme Court refused to believe the argument advanced by Georgia. Sabi ng Supreme Court, hindi itong makatotohanan at taliwas sa pangkaraniwang karanasan ng mga tao. Maliban na lang kung ang plaintiff sa kasong ito ay isang bilyonaryo na sadyang namamahagi ng kanyang yaman sa lahat. Ikalawa, sinabi rin ng Supreme Court na si Georgia ay anak ng dating senador. Mayaman na ang pamilyang ito at mayaman din ang napangasawa niya mula sa isa sa pinakamayaman na pamilya ng mga hasyendero sa Iloilo. Clearly, Georgia could not have been the object of such Christian charity. Gayong hindi naman din kayamanan si Carmen Encomienda. In this case, the Supreme Court ruled that the principle of unjust enrichment finds application in this case. Unjust enrichment exists when a person unfairly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. There is unjust enrichment under Article 22 of the Civil Code when 1. A person is unjustly benefited, and 2. Such benefit is derived at the expense of or with damages to another. The principle of unjust enrichment essentially contemplates payment when there is no duty to pay, and the person who receives the payment has no right to receive it. The CA is then correct when it ruled that allowing Halandoni to keep the amounts received from Encomienda will certainly cause an unjust enrichment on Halandoni's part and to Encomienda's damage and prejudice. In this case, the Supreme Court would also like us to learn that there are verbal contracts of loan. A contract of loan does not lose its effects just because the parties failed to write it down. Dagdag pa ng Supreme Court na kung ang isang loan ay magaganap sa pagitan ng dalawang taong magkaibigan o magkamag-anak, mas madalas na ang mga kautangan na ito ay hindi na isusulat. Contracts are binding between the parties whether oral or written. The law is explicit that all contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. A simple loan or mutuum exists when a person receives a loan of money or any other fungible thing and acquires its ownership. He is bound to pay to the creditor the equal amount of the same kind and quality. In this case, the Supreme Court ruled that the Court of Appeals is correct. If we were to allow Georgia to keep the money for herself, then we would in effect sanctioning a situation where Georgia will be unjustly enriched at the damage and expense of Carmen Encomienda. Also noteworthy at this point is the case of Willem Bumer versus Avelina Amores. In this case, Willem Bumer was a Dutch national who married Avelina Amores in 1980. After 20 years of marriage, their union was dissolved on the basis of psychological incapacity under Article 36 of the Family Code. Importante ang case na ito, kapatid, dahil dito mo makikita ano ang nangyayari sa mag-asawang nagsampa ng annulment under Article 36 of the Family Code. Hindi natatapos ang magiging trabaho mo, kapatid, sa pagpapaanal ng kasal. Naroon din ang iyong tungkulin na protektahan ang yaman ng iyong kliyente. In the case of Bumer, or sabi ng isang professor namin ay Boymer versus Amores, the couple acquired 4 lots in Dumaguete City. Of those 4 lots, 2 had houses built on them. In the action for the dissolution of the conjugal partnership of gains, Willem sought the reimbursement of 1/2 of the value of the houses and 4 lots. He claims they were purchased using the money he had received as disability benefits from his government, and that these were registered under the name of his Filipina spouse because of the prohibition against foreign ownership of lands in the Philippines. For her part, Avelina maintained that the properties were all registered under her name and that she had bought them and paid for them using her own efforts by selling jewelry, Avon, Triumph, and Tupperware products. The Regional Trial Court ruled that the power, tools, and equipment taken by Willem belonged to him alone. Whatever Avelina acquired as her inheritance shall also belong to her alone. The lots that were bought during their union shall also belong exclusively to Avelina because of the constitutional prohibition against foreign ownership of lands in the Philippines. Finally, the 2 houses shall be co-owned by the 2 of them. On appeal, the Court of Appeals affirmed the ruling of the Regional Trial Court. The Court of Appeals applied the doctrine of in pari delicto, or the rule that he who comes to court must come with clean hands. The Court of Appeals pointed out that Willem is not entitled to 1/2 of the price of the lots because he acquired them against the prohibition on foreign ownership. For his appeal to the Supreme Court, Willem advanced another theory. He argued that if the courts were to allow Avelina to keep the lands all for herself, she would be unjustly enriched at the cost and damage of Willem. Sa unang tingin, kapatid, ay parang tama naman si Willem. Mali naman siguro na ang makikinabang lang sa mag-asawa ay si Avelina. Dahil lang ba hindi Pilipino si Willem, ay mawawalan na siya ng karapatan sa kanilang mga naipundar? In this case, the Supreme Court ruled that Article 22 is expressed in the maxim memo cum alterius deter detrimento protest. No person should unjustly enrich himself at the expense of another. An action for recovery of what has been paid without just cause has been designated as an action in rem verso. This prohibition does not apply if, as in this case, the action is proscribed by the Constitution or by the application of the pari delicto doctrine. Finally, the Supreme Court adds that while the foreign spouse cannot own lands in the Philippines, he is nevertheless allowed to own the improvements built thereon. Wala mang share si Willem sa lupa, ay kanya naman ang 50% or 1/2 ng value ng bahay at anumang laman nito. Another case worth discussing is the case of Lorea versus Munoz. This is a decision penned by Justice Marivic Leonen and could be important for those who will be taking the bar next year. In this case, Ludolfo Munoz filed a complaint for collection of sum of money against Carlos Lorea in the amount of 2 million pesos. Munoz was a contractor and he was approached by Lorea to offer him a subcontract for a river dredging project in Ginobatan. Lorea represented that the project was worth 50 million pesos. He would receive a part of the project or a subcontract for 10 million pesos from the lowest bidder. Para sa service na ito, humihingi ng 2 million pesos si Lorea mula kay Munoz. Pumayag naman si Munoz, total may kikitain pa rin naman siya. At this point kapatid, at i-discuss din ni Justice Leonen sa ending na sadyang napaka-irregular ng bidding process ng DPWH. Merong magic na gagawin si Lorea para panalunin ang SunWest Construction sa bidding at ang SunWest naman ang magpapasa ng trabaho kay Munoz. In effect, tatlo silang kikita. Ladies and gentlemen, this is where your taxes go. Fast forward na natin ng konti kapatid, nanalo sa bidding ang SunWest para sa dredging ng Masarawag at San Francisco Rivers. Nabungkal na nila, nalinis na nila at sa darating na tag-ulan ay sana menos na tayo sa baha sa Albay. Natapos ang project pero walang subcontract na napunta kay Munoz. Wala siyang kinita at ngayon ay hinahabol niya ang 2 million pesos niya. The Regional Trial Court ruled in favor of Munoz. The court ordered Lorea to pay not only the money but also interests, damages, and attorney's fees. Pumanig din ng Court of Appeals kay Munoz pero inalis ang damages at attorney's fees. The issue now in this case is whether or not Carlos Lorea is liable to pay Ludolfo Munoz the amount of 2 million pesos. The Supreme Court, speaking through Justice Leonen, ruled that under Article 22 of the Civil Code, every person who through an act of performance by another or any other means acquires or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. There is unjust enrichment when a person unjustly retains a benefit to the loss of another or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. The principle of unjust enrichment has two conditions. First, a person must have been benefited without a real or valid basis or justification. Second, the benefit was derived at another person's expense or damage. In this case, Lorea received 2 million pesos from Munoz for a subcontract of a government project to dredge the Masarawag and San Francisco rivers in Ginobatan, Albay. However, contrary to the parties' agreement, Munoz was not subcontracted for the project. Nevertheless, Lorea retained the 2 million pesos. Thus, Lorea was unjustly enriched. He retained Munoz's money without valid basis or justification. Under Article 22 of the Civil Code, Lorea must return the 2 million to Munoz. However, kapatid, Lorea tried one more argument and that is pari delicto. It is a settled rule that there can be no recovery to an illegal contract. Halimbawa, ikaw at si X ay mga sindikato at inakyat ninyo ang bahay ng isang online seller na alam nating lahat na nanamantala ngayong panahon ng pandemya sa pagbebenta ng mga mahal na face mask, nag-hoard ng alcohol at ngayon ay footbath naman ang benta. Ang total ng inyong nanakaw ay 200,000 pesos pero ang binigay sa iyo ni X ay 20,000 pesos lang. Hindi ka pwedeng pumunta sa korte at ireklamo ang 80,000 pesos na share mo. This is because as a general rule, he who comes to court must come with clean hands. Your hands, while they may be clean from all the disinfectants you may have stolen, cannot be clean because both of you are criminals. To this, the Supreme Court ruled that the application of the doctrine of in pari delicto is not always rigid. An accepted exception arises when its application contravenes well-established public policy. In this jurisdiction, public policy has been defined as that principle of the law which holds that no subject or citizen can lawfully do that which has a tendency to be injurious to the public or against the public good. In this case, Justice Leonen further points out that Article 22 of the Civil Code is part of the chapter on human relations. These are provisions that determine our behavior towards one another. Thus, the rule on unjust enrichment is part of our public policy. If the court allows Lorea to keep 2 million pesos for his promise to rig the bidding of a DPWH project, we are in effect allowing a situation where one person becomes richer on the strength of an illegal promise at the cost and damage of another person. From these three cases, we can now come up with the following rules. Number 1, there is unjust enrichment when one person receives an unjust benefit and that this benefit comes at the expense and damage of another person. 2, the exceptions to unjust enrichment are the constitutional prohibition against foreign ownership of lands and the principle of pari delicto. 3, the exception to the exception of pari delicto is when its application will violate public policy. Marahil at this point ay naguguluhan ka na dito kapatid. Paano ba naging exception ang pari delicto sa kaso ni Boymer versus Amores pero siya naman ang naging basihan ni Justice Leonen sa Lorea versus Munoz? Walang unjust enrichment sa kaso ni Boymer versus Amores dahil hindi naman pwedeng maging owner ng lupa ang isang foreigner. In fact, ginamit niya ang asawa niya para makaiwas sa prohibition. Doon sa act na iyon, dirty na ang hands niya. Sa Lorea versus Munoz, merong unjust enrichment dahil nabudol ni Lorea si Munoz sa halagang 2 million pesos. Pinipilit lang ni Lorea na dapat po ay applicable ang exception. Parehas kami ni Munoz na nag-violate ng batas. Sabi naman ng Supreme Court, applicable man ang in pari delicto ay hindi ka pa rin lulusot dahil bawal ayon sa ating public policy ang manlamang ng kapwa. Kaya in the end, dapat pa rin isoli ni Lorea ang 2 million pesos. One more case under Article 22 would be the case of the University of the Philippines versus Philab Industries. This is probably the most important of the cases I have discussed now, and you will definitely see this case again in obligations and contracts, in civil procedure, and in remedial law review. Sometime in 1979, the University of the Philippines decided to construct a research facility for biotechnology in the UP Los Baños campus. I am oversimplifying the facts, kapatid, but I trust that you will read this on your own. There will be a link to the case in the description down below. The research complex was to be funded by the Ferdinand E. Marcos Foundation in the amount of 29 million pesos and such other funds that UP would need in the future. For this project, the foundation instructed UP to contract with a supplier for laboratory furniture. This is where the complainant in the original case, Philab Industries, came into play. The deal was for UP to contract with the supplier and for the supplier to submit its contract for the review and approval of the foundation. The foundation approved portions of the contract and made partial payments thereon. However, the EDSA revolution happened and the properties of the foundation were sequestered by the government as possible sources of ill-gotten wealth. This resulted in a situation where Philab was holding an empty bag. It sought to collect the sum of about 703,000 pesos from the University of the Philippines because the Ferdinand E. Marcos Foundation has disappeared from the face of the planet. Philab Industries tried to collect from the government through other means. Exasperated, it filed an action for collection of sum of money against UP. The University of the Philippines denied owing any money to Philab. The contract was after all between the foundation and the plaintiff. Philab in effect had no cause of action against UP because UP was a mere beneficiary. The regional trial court ruled in favor of UP. It ruled that Philab was owed the money, but it had no right to collect from UP. It did have a right to collect from the assets of the foundation. On appeal, the Court of Appeals agreed with the regional trial court. It ruled that the contract was between Philab and the foundation. The remedy, therefore, was between the foundation, not against UP. Pagdating naman sa Supreme Court, kapatid, inilaban ng Philab na dapat bayaran ng UP ang 703,000 pesos nila. Kung hindi daw nila babayaran, giit ng Philab ay magkakaroon ng situation ng unjust enrichment, magkakaroon ng laboratory furniture ang UP. Pero kawalan ito sa Philab. In this case, the Supreme Court teaches us that the claimant must unequivocally prove that another party knowingly received something of value to which he was not entitled, and the state of affairs are such that it would be unjust for the person to keep the benefit. Unjust enrichment is a term used to depict the result or effect of failure to make remuneration of or for property or benefits received under circumstances that give rise to legal or equitable obligation to account for them. To be entitled to remuneration, one must confer benefit by mistake, fraud, coercion, or request. Unjust enrichment is not itself a theory of reconvey. Rather, it is a prerequisite for the enforcement of the doctrine of restitution. Sa kasong ito kapatid, sabi ng Supreme Court na walang unjust enrichment. The contract was between the foundation and Philab Industries. The University of the Philippines was a mere beneficiary. The Supreme Court also teaches us the requisites of action in rem verso, or the action for the recovery of a thing from another person based on unjust enrichment. In order that action in rem verso may prosper, the essential elements must be present. 1. That the defendant has been enriched. 2. The plaintiff has suffered a loss. 2. That the enrichment of the defendant is without just or legal ground. And 4. That the plaintiff has no other action based on contract, quasi-contract, crime, or quasi-delict. An action in rem verso is considered merely an auxiliary action, available only when there is no other remedy on contract, quasi-contract, crime, and quasi-delict. If there is an obtainable action under any other institution of positive law, that action must be resorted to, and the principle of action in rem verso will not lie. Ang action in rem verso ay ang tawag sa mga kasong pumapasok sa ilalim ng Article 22 of the Civil Code. Kung ang cause of action or the basis of the filing of the action ay ang principle ng unjust enrichment, ang tawag naman sa specific na action ay action in rem verso. Sana maliwanag yan sa iyo kapatid. Kapag binabanggit ang action in rem verso, hindi pwedeng i-discuss ang konsepto ng solutio indebiti. Meron silang overlap kapatid, pero para sa akin ay malabong-malabo naman silang mapagpalit. Ang solutio indebiti ay hindi na bago kung ikaw ay CPA o nakapagtapos ng legal management. For the rest of us mere mortals, solutio indebiti is just another Latin phrase for us to remember. Solutio indebiti is a juridical relation which arises when something is received when there is no right to demand it and it was unduly delivered through mistake. In order for solutio indebiti to apply, there must be 1. Payment is made by one person. 2. There is no duty to pay and there is no right to receive. 3. The payment is made through mistake and not through liberality or some other cause. Kung susundin lang natin kapatid ang mga requisites na inilatag sa atin ng batas, walang kalituhan sa pagitan ng action in rem verso sa unjust enrichment at solutio indebiti. Solutio indebiti defines for us the relationship between someone who pays and the person to whom such payment was made. Unjust enrichment on the other hand is the result of the payment. Halimbawa, si X ay nakasakay sa isang jeep. Lutang siya, pagod siya at hindi niya namalayan na nakatulog siya sa jeep. Nang muli siyang nagkamalay, nagbayad na siya ng kanyang pamasahe. Pero dahil super traffic at super pagod si X, nalimpungatan siya at muli siyang nagbayad ng kanyang pamasahe. At this point between X and the jeepney driver, the law says there is now a juridical relation of solutio indebiti. X paid twice for his fare. Payment was made and the driver received it. The basis of the payment is mistake. As a result, the jeepney driver was unjustly enriched at the cost and damage against X. Kung sa halimbawa natin, kawatan ng jeepney driver at sinamantala niya ang antok at pagod ni X at dahil dito 2 beses nagbayad si X, then there would be no more solutio indebiti because the basis of the second payment is not mistake but the fraud and deceit of the jeepney driver. There is however still unjust enrichment on the part of the driver because Article 22 does not distinguish as to how we are unjustly enriched. Malinaw yan sa phrase na by any other means. Sa una kong nabanggit na halimbawa, common example ng mga textbooks na solutio indebiti daw kapag sobra ang sukli. Halimbawa, Jacob buys a sack of rice worth 1,250 pesos. He hands over 1,000 peso bill and 1,500 peso bill. Dapat ang sukli niya ay 250 pesos lang. However, ang kahera ng bigasan ay nagbigay sa kanya ng sukli ng 750 pesos. Is this now a case of solutio indebiti? The answer kapatid is no. Pwedeng crush ng kahera si Jacob kaya niya binigyan ng 500 pesos. Pwedeng nabalitaan ng kahera na binahasi na Jacob at tulong na lang niya ang 500 pesos. Pwedeng may galit ang kahera sa boss niya kaya siya nagpasobra ng sukli. There are other causes for the overpayment and all of these causes will unjustly enrich Jacob by 500 pesos at the cost and damage of the owner. Subalit kung sobra ang sukli ng kahera dahil nagkamali siya, dito at dito lang tayo magkakaroon ng solusyo indebiti. If the reason for the payment is mistake, then that is the only time we can have solusyo indebiti. I hope this is very clear to you kapatid. To summarize tonight's lesson, number 1, there is unjust enrichment under Article 22 when a person unjustly benefits and the benefit comes at the cost of expense or damage against a person. 2, the cause of action under Article 22 is unjust enrichment. The remedy is action in rem verso. 3. Article 22 enforces the duty to return the thing. The exceptions are the constitutional prohibition against the ownership of lands by foreigners and in cases of pari delicto. The exception to the exception of pari delicto is when its application will violate public policy. 4. Solusyo indebiti is a kind of unjust enrichment but the basis of the payment is mistake. Pasensya na kapatid at napahaba na naman ang ating discussion. I am constantly looking for ways to improve our lessons and one of the suggestions has been to make longer discussions. Longer lessons take much longer to make and I'd like to know what you think. Let me know kung nainip ka na, nabore ka ba, or information overload na kapag inaabot tayo lampas ng 20 minutes. Finally, there is a quiz for everyone. I hope you participate kapatid so you can test your understanding of the lesson and the principles from past episodes. Please post your scores in the comments down below. However, please do not discuss the questions so as not to spoil the quiz for those who will watch later. If you would like us to continue with our discussion next Friday, please type yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma and I will see you next Friday.